All right, thank you for joining us today for this webinar on statelessness in the U.S., representing stateless persons before U.S. immigration authorities. My name is Colleen Cogill, and I'm a legal fellow with UNHCR. I'm going to begin by introducing our speakers on today's webinar. I'm joined by my colleague, Lindsay Jenkins. Lindsay is an Assistant Protection Officer with UNHCR's Regional Office in Washington, D.C., where her work focuses on issues surrounding access to asylum, detention, and alternatives to detention for asylum seekers in the United States, capacity building, and statelessness. Prior to joining UNHCR, Lindsay provided legal orientation and representation to adults and families held in U.S. immigration detention. And our next speaker is Benach Collopy. Benach is a partner of Benach Collopy LLP. Her practice is devoted to defending and representing individuals in removal proceedings, asylum matters, federal court litigation, VAWA and U visa petitions, waivers of inadmissibility, family and employment-based visa petitions, and complex adjustment of status and naturalization applications. Benach also serves as chair of the AILA National Asylum and Refugee Liaison Committee and is the author of AILA's Asylum Primer. And so at the beginning, I just also want to note that this presentation is being recorded and will be posted on our website after the presentation, and we'll be sending around a link once it's been posted. And you can also have access to the slides on the right-hand side of the screen if you scroll down to where it says Handouts. Thank you. Next one. Okay. Yeah. Oh, yeah. So I just want to hand it over to Lindsay to jump into the presentation.
Great, fantastic. Thank you so much, Colleen, and thank you, Benach, for being here this afternoon, and all of you on the line for joining us on this webinar on statelessness in the United States, and in particular, representing stateless people before U.S. immigration authorities. I'd just like to, first of all, start by commending you all for taking interest in this issue. This is one that UNHCR has worked closely on for a number of years here in the United States, and we're very excited to raise awareness about the issue of statelessness in the U.S., in particular among the legal community. Many of you in your practice come across stateless people in a range of different situations, and so we're really excited to start the dialogue, start a discussion a bit more about how statelessness arises in your potential clients' cases, and ways in which you as a legal advocate can represent that, reflect that, and assist your clients in visibilizing that and resolving their cases as a result of statelessness. So thank you very much. We look forward and are hoping to have a few more of these webinars related to representing stateless clients moving forward as we launch our statelessness representation manual. So just to give a little bit of context, we'll go ahead and start with talking about statelessness in the United States and statelessness generally. UNHCR is the UN agency that is mandated with the protection of refugees and asylum seekers, but we also have the mandate to ensure the protection and reduce, prevent, and eventually eliminate statelessness in the world. That work we carried out in a range of different contexts, but all of it working alongside governments, working alongside civil society, working alongside stateless people to really make sure that those who have no nationality can resolve their situation and become citizens and integrate and full members of society. So what is a stateless person? That's a pretty important starting point for our conversation. A stateless person, as defined under the 1954 Convention relating to the status of stateless people, is a person who is not considered as a national by any state under the operation of its laws. So the 1954 Convention sets out that definition, and it's one that is critical. As you all are lawyers, you understand that each one of those pieces of that definition really carries legal significance, legal weight, something to be analyzed and considered in an individual client's case. But this is the internationally accepted definition, one that is reflected in many countries' domestic laws, but one that in the United States, as you all likely know, there is no official definition of a stateless person under U.S. law. So this is the definition that should control and carry in as you consider your client's stateless case. Additionally, statelessness actually appears in terms of the international legal framework. It comes up in a range of different contexts that we can turn to and look at for sources that address statelessness. There's the right to nationality that is in the Universal Declaration of Human Rights. There's the right of the child to acquire a nationality, which we find in the International Covenant on Civil and Political Rights, as well as the Convention on the Rights of the Child. You have the prohibition on discrimination in acquisition or deprivation of nationality, which again we find in the ICCPR. In the CERD, the Convention for the Elimination of All Forms of Racial Discrimination, as well as the Convention for the Elimination of All Forms of Discrimination Against Women, CEDAW. Additionally, and very key to any analysis on statelessness are the two fundamental international tools on statelessness, which are the 1954 Convention relating to the status of stateless persons and the 1961 Convention on the reduction of statelessness. So those are that's really the international legal framework that we use to establish the rights of stateless people, to define and inform the definition of a stateless person and what the rights of stateless people are. How does statelessness happen? How does someone end up without a nationality? Well, there are a range of different causes that have been identified around the world that give rise to statelessness. Sometimes it might be a conflict in nationality laws. Additionally, there might be discriminatory nationality laws that are in place, either that discriminate on the basis of ethnicity or gender, or potentially that denationalize people on the basis of a discriminatory ground. Additionally, movements from someone's country of birth and birth registration practices. If someone was born in one country and moved quite early without having registered birth to another country, there might be potential risk for statelessness that arises in that context as well. Another way that statelessness emerges is in the context of new states and changes in borders in the context of state succession. We'll touch on this a little bit later on, but for instance, in the context of the former Soviet Union, which is actually a population that we see quite often in the United States as a potential stateless population, would be those who were perhaps outside of the Soviet Union seeking asylum, studying, otherwise, and were outside when the Soviet Union broke up, and then the resulting countries actually had residency requirements that folks could not fulfill, and thus ended up stateless outside their country of origin. And then again, loss or deprivation of nationality. This can happen on a range of grounds. It can become particularly problematic and concerning for the asylum context when that loss or deprivation is carried out on discriminatory grounds. And this is something that we'll touch on a little bit later in today's webinar as well. But wanted to give you a context of how this happens. How can this be? How can it be that someone is living in the world without a nationality? I would point out, so UNHCR, as we have the mandate to ensure the protection of stateless people and to work with states to reduce, prevent, and end statelessness, we have developed over the years, very similar, you all may be familiar with our handbook on refugee status determinations. We very similarly developed a handbook on the protection of stateless persons that covers a range of different areas, both procedural and interpretive, legal interpretive, related to the implementation of the statelessness definition. So this is a resource that we have developed, this handbook, and one that we will make available to you all. It's available already online at UNHCR.org. but it's one that we'll go ahead and follow up for you all who are attending today to have at your fingertips. It's very helpful particularly in identifying stateless people and helping you to understand better who is stateless when someone comes before you, who is stateless, who is not stateless. So for instance, if by definition, someone who completely lacks a nationality is a stateless person, whereas someone who perhaps is a national of another country or a citizen of another country, but is unable to get travel documents or otherwise would likely not might not be stateless. It could be an indication of statelessness, but that person might not be stateless. So this handbook is very helpful in digging in on some of the ways in which and understanding the analysis of who is a stateless person, and also in particular for you all in your practice, understanding the ways in which someone can provide proof, both legal and evidentiary proof of someone's statelessness. So this is a great resource for attorneys. It's also a great resource for governments and UNHCR around the world as we work to identify this population and advocate for their protections. So this is a map that we just wanted to draw your attention to. We've raised who is a stateless person. We've talked a bit about how do people end up stateless. And resources to analyze who is stateless, but just wanted to flag for you all, as I'm sure you're wondering, as clients come into your office and perhaps trying to start identifying who is stateless. This is a map from 2016 from the U.S. State Department that shows significant populations of statelessness around the world, as well as some of the causes of statelessness. This is available online from the U.S. Department of State. So shifting gears, thinking about stateless people in the United States. So in the U.S., typically we do not see that people are born stateless in the United States. This is because the U.S. has very strong, what we refer to as jus soli, nationality laws that have very strong protections against statelessness. Basically, that means if you are born on the territory, you are a citizen of the United States. And this is critical as a protection against protracted situations of statelessness, even if two parents are stateless in the United States. If their child is born in the United States, we don't see multi-generational situations of statelessness typically arising in the United States. And those are fundamental rights to nationality and treatment under U.S. law that we have here as provided for in the 14th Amendment. However, what we do have for stateless populations in the United States are people who have come to the United States from other countries and either entered as a stateless person or perhaps came here as a citizen of one country and then for a range of one of those reasons that we outlined before, maybe became stateless while here. So this is very relevant for you all in your practice as immigration attorneys, because that means that basically any stateless person in the United States is likely to be someone who is in some sort of immigrant positioning, has come here from another country and could potentially be a client of yours. So it's going to be pretty important to be able to understand who's stateless, but then also identify some of the ways that you can be of assistance. Now, what we do not have an estimate of currently the number of stateless people in the United States. That is a result of the fact that because there is no statelessness definition under U.S. law, there is no official U.S. government counting of the number of stateless people in the United States. There's no determination, so there's no counting, and thus there is no official estimate of the number of stateless people. As a quick aside, that is something that this office is currently working on, and we're hoping to have our first estimation of the number of stateless people in the United States sometime next year. So just as a teaser for coming attractions next year, and please please keep your eyes and ears peeled. We'll be hopefully launching that report next year. But in the meantime, what we do know, so even though we don't know the number of stateless people that there are in the United States, we do know some of the hardships that they do face. So I think what I will do is our next slide, we are going to, I'm going to stop talking for a moment, and we are going to let one of the stateless people who our office has worked with in the past to actually tell his story a bit so you all can see that. This is Mikhail Sebastian's story.
When I was planning my vacation for the New Year holiday, I decided to go to American Samoa, and it says that it's U.S. territory. And I went to come and see just sightseeing. That first day of arrival was kind of exciting because I was coming for vacation, and I was thinking that I'm going to be spending only 4 days.
Mikhail was born in the former Soviet Union, and he and his family, because of threats and discrimination that they faced based on their ethnicity, had to flee from one republic to another over the course of several years. Because of that flight, they never satisfied the residency requirements in the breakup of the Soviet Union to become a citizen of any of the resulting countries.
He received the permission to travel to American Samoa, sort of not really knowing what he was getting into, I'm afraid.
I came here for only 4 days vacation. That's only clothes I brought here. I didn't plan to stay here so long. When the first articles were published about me and about my case, I was kind of interested what audience can say, and some of them were like thinking, what he's complaining for, he's in a tropical island, how bad it can be. It's not about being stuck about tropical islands. We're talking about statelessness, and a person doesn't belong to anybody or anywhere. When I came to American Samoa and all this disaster happens to me, and I start paying close attention to statelessness, I realized that apparently the United States, as one of the developed countries in the world, doesn't have any provisions or special law protecting or reducing statelessness.
Mikhail's case actually raises a larger issue, and that is the lack of legislation in the United States to allow stateless people to acquire citizenship.
Statelessness takes all human away from you, and it demonizes you a lot, and you start thinking about so crazy stuff. And I was thinking about suicide on many occasions, but something stopped me.
Our own courts have found statelessness to be a punishment more primitive than torture. I mean, this is something that we as a country have deplored for decades, and yet we have stateless people living within our borders. We have the complete power to help them, and we have neglected them for too long.
UNHCR was very happy to receive the news that Mikhail was granted parole. It was an important step forward, but it was also in line with a number of steps that DHS has taken to lessen the daily hardships that stateless people in the United States face.
When I learned that I was allowed to come back to Los Angeles, I took like a deep breath. Then I got actually really happy, and I had tears coming out from my eyes. I just don't want to be trapped anymore in limbo. I don't want to report to immigration anymore. I want to be able to work without obtaining working permit. And I want to go see my sister, my nieces.
Mikhail fell through a hole in U.S. law, and he was brave enough to speak out about it. In speaking out, he galvanized the support of students, of advocates, of lawyers, of journalists, and even a congressional office. But he's still stateless.
We are a global leader on advocating about human rights around the world, and I want the United States to show example that we can do something to reduce statelessness. I don't want to spend the rest of my life and die as a stateless person. I want to be known that I'm a citizen.
So Mikhail's story is very unique in the situation that he found himself in, obviously. But unfortunately, many of the themes that we heard from his own words, many of the hardships that he faced and continues to face are many that stateless people in the United States also face. In 2012, around the time that we were working with Mikhail's lawyers and with Mikhail to resolve the situation, we released a report called Citizens of Nowhere, Solutions for the Stateless in the United States. That's also found on UNHCR's website, and we'd be happy to circulate it after this webinar. But really, the hardships that it basically, the report sets out who a stateless person is, but then really digs in on some of the hardships that stateless people like Mikhail face in the United States. These include no or limited work authorization. Many times stateless people are either have a final order of removal and they can't be removed from the United States, or perhaps they haven't been placed into removal proceedings yet, so they just don't have access to work authorization, or they have to apply every year. Additionally, restrictions on travel. That became very clear. Mikhail really pushed the limits of where he could travel within the United States. But beyond the U.S. and some of the U.S. territories, you really can't leave the United States, and that ends up leading to long-term and indefinite separation from family members. And so you have another stateless person that our office works with has been separated from her son for over 25 years, unable to see her child because she is stateless in the United States and literally is stuck in the United States without any option of resolving her situation, and so suffers from that hardship. Additionally, so we have a lack of access to benefits. Oftentimes, stateless people who have removal orders might be subject to ankle monitors. They're required, as are all individuals who have a final order of removal and have been released from detention, to contact embassies requesting that they be accepted there. And as you can imagine, if you are not a citizen of any country of the world, contacting embassies to try and convince them to allow you to be removed to that country can be rather challenging and seem quite difficult for a stateless person. And then obviously too, in-person reporting requirements, all of these sorts of things that many times people with removal orders face, but it's particularly acute in the situation of stateless people because they have no way of resolving their situation on their own. They are not a citizen of any country through no fault of their own, and yet find themselves in, as Mikhail has so aptly described, a state of limbo without any option of resolving the situation. So, without a definition of a stateless person under U.S. law, and there's obviously currently no pathway toward resolving a situation of statelessness just on the basis of being stateless. However, there are many options that are out there under existing U.S. law and policy that attorneys can provide assistance to their clients in reducing some of the hardships that we saw. And in fact, even perhaps statelessness can be a key element in providing for relief under existing benefits that might exist, or relief from removal that might exist currently under U.S. law. So what UNHCR has done, consulting with a group of key legal experts, including Dree and others, we have come up with the very first ever, to our knowledge, legal representation manual for representing stateless clients before U.S. immigration authorities. The idea here being that despite that lack of definition of statelessness is still very relevant under current U.S. immigration law and policy, and lawyers are in a particularly strong position to help stateless clients alleviate those hardships and perhaps even resolve their situations. So the way that the manual is structured, as you will see, there are 3 chapters. The first is understanding, identifying, improving statelessness. In this way, we rely greatly on the international legal framework as well as UNHCR's handbook on the protection of stateless people. Like I mentioned earlier, that's that black handbook that provides an overview of the definition of statelessness as well as the evidentiary requirements and otherwise for proving statelessness that UNHCR has developed over the year as a touch point. Additionally, Chapter 2, we talk about avenues for relief for stateless clients. That covers a range of different issues, including looking at asylum petitions for stateless individuals, which Dree is going to go more in depth on today. But additionally, looking at other options of potentially deferred action, looking at how to raise statelessness in the context of a master calendar hearing, what are some of the procedural aspects. Additionally, looking at how to raise or the relevance of statelessness in merits hearings, whether that's on a petition of referral, withholding of removal or deferral of removal, whether that's in an asylum claim, whether it's in the context of cancellation of removal for certain non-LPRs. And then additionally, we look at the potential relevance of statelessness in the context of motions to reopen. There are also Chapter 3, we're starting to look at alleviating other hardships. So some of those hardships that we highlighted before, looking at detention or other restrictions on liberty, looking at orders of supervision, as well as some issues related to employment authorization. And this is some of those right there. So really there are a number of ways that we were excited to explore with legal experts of how statelessness can arise and be addressed and start to understand and move forward and really address some of the needs of stateless people. And we're very excited to put this out into the world and get the conversation going with you all. And with the experts that fed into the process. So all of this by way to tee up for Dree, who's going to be digging in here on seeking asylum and the relevance of statelessness in the context of asylum. And then we'll come back and we'll be happy to answer additional questions about statelessness and about how this might arise in claims. But I hand the microphone over to Dree.
Great, thank you, Lindsay, and thank you, Colleen. It's great to be here, and I hope everyone finds this webinar to be really useful. I think for me, one of the greatest uses is just understanding that this is an issue and that it's something that we should all be screening for during our intake process with our clients or consultations. I think it's something that many attorneys don't even really think about. And sometimes clients themselves might not even know that they're stateless when they come to you. And so it's really important for us as attorneys to be aware of this issue and of the fact that there's probably thousands of stateless people, maybe even more, in the United States. I'd be interested to see those numbers once UNHCR gets those out. But you know, I at the AILA National Conference this year, I spoke with several attorneys during the AILA Authors Panel, and there were like 2 or 3 examples of even just attorneys coming up and asking questions to me about asylum claims of people that probably were stateless or at least had issues surrounding statelessness involved in their cases. And so it really does come up, and it's something that we should keep at the forefront of our minds. So with that, I'd like today to talk to you specifically about asylum. I know they're going to focus on other webinars on other issues and areas of U.S. representation where statelessness is important to consider. But for today, I'm going to focus on statelessness and how it can come into play with the definition of refugee for purposes of presenting an asylum claim. And also talk about some of the bars that you might want to give some extra attention to with regard to statelessness, the bars to asylum, that is, and then talk through kind of ways to prepare, tips for preparing the asylum application itself, and then again presenting that application kind of pitfalls to watch out for and things like that. So hopefully everyone will find this very, very helpful as far as issue spotting moving forward and then presenting your claims for your stateless clients. So statelessness alone doesn't per se warrant asylum protection. There's several cases in the U.S. that have dealt with statelessness, and we're going to talk about some of them throughout this presentation today. But several circuits have said specifically statelessness alone is an insufficient basis on which to grant asylum. But that does not mean that statelessness isn't important and isn't relevant to asylum, because statelessness can really be a very central part of an asylum claim. And it can be relevant, as you'll see moving forward in this presentation, that it can be relevant to every single element of the definition of refugee. So that's where I want to start, by kind of breaking down the definition of refugee under the Immigration and Nationality Act and talk a little bit about how statelessness can come in to each one. So first, when we are building an asylum case, we have to show that our client is outside their country of nationality or their country of last habitual residence. So this first element, statelessness, already is a very central concept. The threshold question for any client seeking asylum is, well, where are you seeking protection from? And sometimes that's where they were born, sometimes it's from another country, and that's where you really need to have a grasp on, you know, where is my client a citizen? Where are their parents from? Where were they born? These kinds of questions are really important. And sometimes clients are dual citizens as well, and that's something that is also important to know. So these questions are really key to starting your exploration with your client about whether they might be eligible for asylum. So if they're a citizen, obviously, of a country, and that's the country they're claiming asylum from, then you go from there with that country. But if your client isn't a citizen of a country, if they're stateless, you have to look, the inquiry changes to where did they last habitually reside. And that's not an easy question to answer sometimes because, unfortunately, we don't really have a definition under U.S. law of last habitual residence. And so what we have to look at is the statutes and the regulations. And in the Immigration and Nationality Act, there's a definition of residence, which says a place of general abode or the applicant's principal actual dwelling place in fact without regard to intent. And then the regulations define habitual residence as a place of general abode or a principal actual dwelling place of a continuing or lasting nature. So the regulations and the statute are slightly different, which has led to differing interpretations in the courts. And I put 3 case examples there on the slide, and we can just talk briefly through them, but they're basically examples to show you how courts have applied the term last habitual residence quite inconsistently. So the Sixth Circuit, in this case, UDA versus INS, the court basically said that you should look to the individual's birth country or the country where the individual resided for a certain period of time. And either of those could constitute the country of last habitual residence. The Ninth Circuit, in the Elian versus Ashcroft case, also considered a stateless asylum applicant's claim in the context of both his birthplace and his country of last habitual residence. But then the Third Circuit used a much more quantitative approach, focusing on the actual length of time that the person resided in the country. So in this case, Paripovic, the Third Circuit held that a stateless Croatian who last habitually resided in Serbia, that he had last habitually resided in Serbia because he had lived there for 2 years, even though he didn't intend to reside there. So the Third Circuit said the person's intent doesn't really matter. It's the amount of time where they lived that's what's relevant. And some experts have argued that it should actually be a more qualitative approach, meaning that the individual's intent to remain in that certain country should also be considered under the last habitual residence analysis. And so the point here is that it's really important to talk to your client about, where did they live? What was their life like? How long did they live there? Questions like that. It's really important to do a thorough investigation with your client in the beginning if they're not a citizen of any country. And to also remember that even if somebody has a passport from a particular country, it doesn't necessarily mean that they're a citizen of that country. As Lindsay mentioned, there can sometimes be a law that gets passed after the person has been issued the passport that denaturalizes them. And so really make sure that you have a thorough understanding of your client's citizenship, or if they're stateless, where they last habitually resided, so you know where to do the rest of your asylum inquiry related to, which country. So the next element of asylum that I want to talk about is persecution. And because we always have to consider, in an asylum case, does the harm rise to the level of persecution? And so again, this is an area of the law where we don't have a definition of U.S. law. What is persecution? It can be physical, it can be psychological, it can even be, in some extreme cases, a deliberate imposition of severe economic disadvantage or deprivation. And so even if the harm alone doesn't rise to the level of persecution, like some of the case law says that, statelessness alone is not persecution, it's really important to consider kind of the broader socio-political context in the country in question. And you need to consider that cumulatively with other harm and other factors involved. So those other factors are kind of under 2 categories. One, what were the circumstances under which someone was rendered stateless? For example, did the government pick a certain group of people to denaturalize? And is that denaturalization based on a protected ground. Those circumstances might be relevant to whether statelessness is persecution. And then the effects of statelessness are also very relevant to whether the harm your client suffered rose to the level of persecution. You heard in the video, Mikhail talked a lot. At one point, he said he was even suicidal. So there's many effects that statelessness can bring on people, psychological and otherwise. For example, stateless people often face insurmountable obstacles to securing access to even their most basic rights, like education or right to work or health care. And so it's really important to explore all of those with your client. What were the circumstances under which they were rendered stateless, and how did that affect them in their day-to-day life? So it's really, really important to go through all of that and to remember that even, economic deprivations, things like that can be relevant. And so you want to cumulatively present all of those. And then there's two case examples there on the slide. One's from the Sixth Circuit and one's from the Seventh. And those you should also take a close look at, because the courts found that the denationalization that resulted in statelessness in these cases were on account of protected ground and therefore could lead to it being persecution. And so you really should take a look at those two cases and compare them to your client's facts and see if there's anything that you can highlight from those there. Once we've looked closely at the harm that our clients have suffered, the next question is, well, was that harm suffered in the past, or is this harm that our clients fear might happen to them in the future? And as we know, if our client demonstrates past persecution, there's a presumption that they also have a well-founded fear. And that presumption can be rebutted in two different ways: by showing that your client can relocate internally within the country and be safe, or showing that there's been a fundamental change in circumstances, in which case your client is no longer in danger. And the fundamental change of circumstances is where statelessness can sometimes come in. There's an example there on the slide, again, the Uda case from the Sixth Circuit. In that case, the Sixth Circuit considered a stateless Palestinian who had been expelled from Kuwait, where she grew up, and then fled to Bulgaria. The judge and the board found that they found that she had suffered the requisite persecution in Kuwait, but then rejected the well-founded fear claim because they said, well, she is stateless, so she couldn't be permitted to re-enter Kuwait. And that was a changed circumstance that they said rebutted the presumption of a well-founded fear. And then the Sixth Circuit came back and said, well, no, there's no support for the proposition that an asylum applicant is precluded from seeking asylum because the country that they're seeking asylum from won't take them back. They said that she has a credible fear of persecution if she returned to Kuwait, and they ordered the board to consider the fact that she was expelled from Kuwait in doing its analysis on remand. And so it's really important to note that, just because someone was rendered stateless and can't go back to their country legally, that's not really, the circuit courts may not buy that as a changed circumstance that rebuts the past persecution. It's also important to remember here, when you're thinking about past persecution versus well-founded fear, that denaturalization can happen before or after somebody flees from their country. And so a lot of times these cases, there may be no past persecution at all, but only a well-founded fear. So did the law change after they left their country? Or sometimes maybe the law didn't change at all, but maybe the application of the law changed, or the interpretation of the law. And so it's really important to look at those factors as well in whether your client, even if they didn't suffer anything in the past, might have a well-founded fear moving forward. And in that case, it's important to remember, if you have a well-founded fear claim only, that individualized harm is not required. So you can look at oftentimes statelessness impacts large groups of people. And so you can look at whether there's a pattern in practice of targeting people who are similarly situated to your client, and then also establishing your client's inclusion in that group of similarly situated people. You can also consider whether your client is a member of a disfavored group. In the context of statelessness, groups as a whole are often harmed, as I said, so you want to show in your asylum claim both the extent and severity of the persecution that your client suffered, and also show, or that your client's group has suffered, and then also show your client's individual kind of risk factors for also suffering those same types of harm. And then finally, again, statelessness can happen at any time in the asylum process, or even after your client has already been ordered removed. And so even if your client comes to you with a seemingly final case with a removal order, you should still consider statelessness and think about whether it might be grounds for reopening your client's case, for example. And there's a great case in the Second Circuit, Gerbina versus Holder, which you saw David Baluarte, and he was on the working group, and then Mario Russell, and I think Mario was the attorney in the Gerbina case. So maybe you'll get the chance to hear from Mario on future webinars. Hopefully you do, because he's great. But he represented Gerbina, and that was a case in the Second Circuit that addressed motions to reopen based on an applicant's revocation of citizenship in Kazakhstan. And there's also in the manual, the new manual that UNHCR is putting out, in one of the appendices, there's a copy of the opening brief from that Second Circuit case, Gerbina. So definitely get your hands on that, take a look at it. It's really helpful and provides a great example of how to make a case for reopening a seemingly dead case based on statelessness. Next, we're going to talk a little bit about nexus. And again, nexus obviously is where asylum claims often fail. And so we really need to think about, when we're making an asylum claim, what is the motivation of the persecutor, and is it one of the 5 protected grounds of race, religion, nationality, social group, or political opinion? And then we need to think about, how do we establish the persecutor's motive? We can establish that through direct evidence or circumstantial evidence. And so in cases involving statelessness, oftentimes we have direct evidence. For example, if the country's law changed and it specifically targets a group based on a protected ground, and it says that in the legal, in the law, in the language, then that's obviously direct evidence of nexus. But sometimes it's more circumstantial. Oftentimes persecutors, including governments, don't announce to people why they're persecuting them. And so what we have to do is look at the circumstances surrounding the harm. And so circumstantial evidence oftentimes comes in asylum claims involving statelessness. For example, we may need to show, this nationality law changed. Maybe on its face, it's neutral, but how was it applied? Who was it applied to? How was it interpreted? Those kinds of questions can be really important. And a decision to deny nationality to a certain group, again, might not be in the language of the law itself based on a protected ground, but you might look into the legislative history of the law, or use an expert on the country's legal system to explain that, the real motivations for this denaturalization law were because of this group's ethnicity or gender or some other kind of protected ground. And then there's just some examples there on the slide of some common protected grounds for cases involving statelessness. Oftentimes they come up in ethnicity, race and nationality cases, and there's an example there from the Seventh Circuit as well as the Sixth. Sometimes it's based on an individual's religious beliefs or practices, and so there's an example there in the Seventh Circuit as well. And then political opinion can sometimes be a motivation for a government to make someone stateless as well. So there's an example from the Ninth Circuit on the slide there. So I invite you all to read those cases really carefully. I think presentations are really boring when people kind of recite case law, so I will give that to you to go through. And they're really interesting cases, so you should read them and think about how they might apply to your own clients' circumstances. And then just finally, with regard to social group, I think that there's probably, when you have a stateless person come in your office, there's a really almost knee-jerk reaction to be like, oh, social group, stateless people. But you really want to be careful there because, again, we want to avoid circular claims. And so if the harm itself is statelessness, defining your group as stateless people would probably be a circular claim that would not be successful. And so just be really careful there about thinking through, like, what is the harm and how can I define my group that's not tied to that harm directly. And then finally, I didn't make a slide on this because there wasn't enough information to put on it, but when we are presenting an asylum claim, we always have to identify who the persecutor is. And in most cases involving statelessness, the persecutor is almost always the government, because usually the question of deciding nationality is a state function. But I haven't seen a private actor statelessness case, but maybe there could be one someday, so keep your eye out. But usually it's going to be a government actor. And then even if we meet all of the elements for asylum, our clients can still be barred from being granted asylum if one of the bars to asylum eligibility applies. And statelessness can come in, questions of statelessness in the bars as well. So I just wanted to flag a couple of those for you. First, the 1-year filing deadline. Clients have to file for asylum within 1 year of their entry to the United States, and there's limited exceptions to that. And I think that both exceptions could come in. Statelessness could trigger exceptions to the 1-year filing deadline under both of these, changed circumstances and extraordinary circumstances. Changed circumstances is the obvious one, right? If someone has already entered the U.S. and then while they're here, perhaps a law changes or war breaks out and the country's boundaries change, something like that might happen while your client is in the United States, and that might be a changed circumstance that is material to their eligibility for asylum. And so they might be able to apply even beyond the 1-year deadline. And I also wanted to flag with that one that you can take delayed awareness into account when you're thinking about, did they file within a reasonable time of the changed circumstance? So someone who's in the U.S. might not be following really carefully, like, the laws that are passed in their home country and things like that. And so maybe they didn't even become aware that the law had changed and that they had lost their citizenship for, it could be a long time, right? And so if your client suddenly became aware and that made them very afraid of persecution, then you need to make that argument that their awareness of the changed law was delayed, and be able to document that as well. Extraordinary circumstances could also come into play. The obvious one that comes to mind for me is the psychological mental health issues due to the effects of statelessness. So maybe, like you heard Mikhail, and you could even hear in his voice in the video, how shook he was from being stateless and emotionally. And so, that could contribute to someone's delay in seeking asylum in the United States is mental health. So there's probably other extraordinary circumstances as well that you'll want to explore, but we just wanted to flag those two. Firm resettlement is also an area, I think, where statelessness can become an issue. And I think mainly the important thing to remember is that firm resettlement is a distinct question from last habitual residence. Someone can habitually reside somewhere without having firmly resettled there. And so that's important because you may have, in the case of a stateless applicant, you've gone through and made all your arguments why your client's claiming asylum from country X because they last habitually resided there. And then the government might come back and say, well, they firmly resettled there and they're actually a citizen of country Y, and so therefore they're barred from asylum because they've firmly resettled. And so it's just important to remember that habitual residence is a completely different concept from firm resettlement. And I think that can get kind of confusing from time to time in your own head, even when you're thinking about these issues. And with that, just flagging that the key question for firm resettlement is whether the person had an offer of permanent residence or citizenship in that country. And so if you're arguing statelessness, right, they probably didn't have a permanent offer of permanent residence or citizenship in that country. And so your arguments for statelessness really help you combat any argument by the government that your client is firmly resettled and barred from asylum. And it's also important to remember that even if your client did have an offer of some kind of residence, that the conditions of their residence there need to be considered. If they were so restricted by the authority of the country that they weren't actually resettled, then that's an exception to the firm resettlement bar. So for stateless people, they might have very terrible conditions that they're living in. They might not have access to, again, the most basic rights of housing, education, healthcare, property, things like that. And so if DHS or a government entity is arguing that your client has firmly resettled somewhere and is barred from asylum, you want to also think about, well, what were the conditions in which they were living? If they were stateless, they probably did not have good living conditions, and that could be a good support for your argument that they didn't firmly resettle. So just in our last kind of section of tips, and I've been giving some tips throughout, but more kind of mechanically speaking, wanted to flag a few things when you're preparing the asylum application itself. First, when we're completing the I-589 form, there's several questions that I wanted to flag for you that are important to kind of stop yourself before auto-filling things out. On the first page, especially, there's at least 3 or 4 questions that involve statelessness if your client is stateless. So there's, what is your present nationality or citizenship? If your client's stateless, you should write stateless there. What is the city, country of birth, or nationality at birth? You can answer that, but you may want to do an addendum saying, yes, they were born here, but they're not a citizen there for these reasons. What country issued your client's last passport? Oftentimes the government will say, well, your client has a passport from that country, so therefore that's evidence that they're a citizen there. And so it's really important, again, to think of doing an addendum if they have a passport from a country, to say, yes, I have a passport from this country, but I'm not a citizen here for these reasons. Let's see, protected grounds. So when we get a couple pages in, before I get to that, also be careful about the section where you're entering all the information about the family members and their nationality and citizenship, because that could be used to argue that your client is also a national or citizen of that country. So just make sure you do a thorough analysis with your client. They might say, well, my parents are citizens of country X, but I'm not. And you need to have a thorough understanding as their lawyer why that is legally. And again, your client might say, well, my parents are citizens of country X, so therefore I think I am too. And again, that's where you as the attorney can come in and say, well, let's just make sure. Let's look at the laws of country X and make sure that you actually are a citizen. Because if they're not, then you have to base it on last habitual residence and go through all the statelessness analyses that we've talked about. When you're looking at protected grounds, you want to be sure, and these are getting into the more kind of long answer questions on the 589. I think they're pages 4 through 8 of the 589. You want to be sure to include descriptions of the country's nationality laws and policies and how they have been interpreted and applied when you're explaining, what is the harm or why your client has a fear. Providing descriptions of the patterns and practices in the country with regard to your client's protected traits. When you're describing the harm that they've suffered, again, you have to think back to, well, what is our goal? We need to show that the harm rises to the level of persecution. And so for stateless people, that can involve a lot of different types of harm. So you want to include all of those on the 589. And remember that it's the cumulative effects of the harm that is important. And if you are talking about well-founded fear of future harm, again, focusing on, even if your client has not suffered harm themselves, patterns and practices of harm of particular groups of people in that country that your client might be a part of. And then time spent in other countries. We just talked about habitual residence and firm resettlement not being the same thing. So just keeping that distinction in mind when you're answering that question. Same with 1 year filing deadline. If your client is applying after the 1 year deadline, you want to make sure and include any changed circumstances and description of any delayed awareness of those circumstances. And then just finally for the 589, use addendums to provide additional explanation. The form oftentimes doesn't give you a lot of wiggle room for explaining things, and usually stateless people have a lot to explain because it's not as straightforward as others. So use your addendums on the 589 form. And then this slide is just a list of evidence that you really want to consider attaching to your application for your client. Number one, if it's a law or policy that's been changed, you want to attach that to show why you're basing your claim on last habitual residence instead of where your client was born, for example. And with last habitual residence, you want to show not only the length of time that they spent there, but what the conditions were like there, how their time was spent. And then, again, documenting all different types of harm, anything from employment discrimination to psychological harm to inability to attend school, things like that. Witnesses can be really helpful for showing patterns and practices in a country for harm as well. And then, obviously, your normal country conditions evidence, if you can find country reports and articles showing that there's pattern and practices by a government against a certain similarly situated group of people, you'll want to include those as well. If it is based on a law change, you want to be sure and document when did the law change and when did your client become aware of those changes. And then experts can be really, really helpful because oftentimes I think statelessness is very confusing and people don't know much about it. They'll know everything about it once UNHCR's manual is shared with the world, but meanwhile, experts, need to be used probably in stateless cases if you can, especially if it's based on a law change that is maybe facially neutral, but the application and the history of the country really communicates that, this law is targeting a certain ethnic group or religion, for example. And so there's different types of experts listed there that might come in or that you might want to consider using. And then also, UNHCR has their, what is statelessness? They have their manual, and that's also part of this new manual. There's a whole chapter, Lindsay said, on making statelessness determinations and in the US when we don't have our own laws to do so. And so sometimes it might even be helpful if it really becomes a big issue in your case. Is your client actually stateless? You might want to consider reaching out to UNHCR to see if they might provide a determination, like an expert opinion saying, well, based on our manual and the international law, we determine that this person is stateless for these reasons. And that can be really helpful and authoritative for a judge, especially given that we don't have our own US domestic laws for providing such a definition. And then as far as other tips and strategies, when you're making a defensive claim, and there's a great section on in the manual about master calendar hearings and other merits hearings as well, but really think about master calendar hearings. I think attorneys sometimes, I can't tell you how many I've gone to where you sit and you just see attorneys saying, automatically admitting everything, conceding removability, just to get to the relief phase. And so it's really important not to do that if your client is stateless, because I've never seen an NTA where it says your client is stateless instead of your client is a native and citizen of country X. And so you want to be ready to deny that factual allegation if you're basing your claim on statelessness. And if your client is indeed stateless, you'll want to be ready to deny that and then explain and articulate why your client is not a citizen of that country. Sometimes, however, it might be a strategic decision that you might want to make not to deny that allegation. So, for example, if the country listed is where the client wants to claim asylum from and the claim isn't based on statelessness at all, really, then you might just want to leave it there and admit that and move on from there. So really think strategically and pause if you might have statelessness involved in your case before just automatically admitting or denying allegations during the pleading process. And then, as in most asylum claims, we want to decline to designate a country of removal. And then don't let statelessness confuse you. That sounds like an obvious tip, but I think it can be kind of easy to get confused by it because statelessness itself is a type of harm, but it can also cause other types of harm. And so just keep that in mind when you're developing your legal theory, because sometimes you can start getting really circular in your thinking. And so I think, if that happens and you start getting confused or you start kind of going in circles, what helps me is always to go back to the three main questions. What is the harm? Who did it? And why did they do it? And sometimes it's even helpful to kind of write that down. And that can help you kind of avoid the circular thinking. And then finally, identifying statelessness early in the process is key. Make it a part of your intake process, like I said, because even outside of the asylum context, statelessness can be relevant. And I'm sure UNHCR will do a lot more lovely webinars to address the other types of cases where statelessness can come into play. But definitely do make it a part of your intake process. Because early identification is key to all of these things. Number one, developing your legal theory, like we talked about throughout this presentation. Even maintaining your client's credibility, because, for example, in the pleadings, if you admit that your client's a citizen of country X, and then when it comes to the merits and you're saying, no, my client's stateless, then they might say, well, why did they admit that they're a citizen of this country? So you really want to get a handle on things early on. It can also help increase exercises of prosecutorial discretion We are seeing kind of prosecutorial discretion not really existing much anymore, but I think if your client is stateless and you have good evidence of that and how that might impact your client, it can be persuasive in many different ways. So think about that as well. And then avoiding lengthy detention is a big one, and there's a section in the manual on that as well. If ICE does not have a country to remove your client to, they can't indefinitely detain your client. And that's all set out really clearly and helpfully in the new manual as well, the legal authorities for making those kinds of arguments. And then again, coming back to the motions to reopen, statelessness and identifying it can really even revive seemingly final cases. So really think about statelessness no matter what stage of the case you're in. And hopefully all of those tips will be really helpful to you, at least as far as issue spotting with your clients. And number one, identifying that your clients actually are stateless if they are. So thank you.
Thank you so much, Dree. That was immensely helpful. And I would just flag that much of what Dree covered, including those really helpful practice points, are reflected in the manual as well.
Great.
Great. So thank you, Dree and Lindsay. And now we're going to go over a quick case example. So looking at these facts and applying what we talked about today to look at what information UNHCR would think is relevant, as well as how an attorney might approach the claim. And after we go through this case example, there'll be time for questions. So if you have a question, there is a space on the right-hand side of the screen to type in your questions, and we'll be sure to address those once we finish this hypothetical. So I'm going to quickly read the facts of this case. Martha was born in country X. Her mother was a member of an ethnic minority group, the Bunta, and her father was a member of the predominant Binta group. When Martha was born, the nationality law of country X allowed for married women who were of a minority ethnic group but were citizens of country X to convey nationality to their children, so long as the father was a member of a majority ethnic group. This could be proved through presentation of a birth certificate, which Martha's parents obtained and duly registered. Her parents were married when they had her, and both were citizens of country X. When Martha was 20 years old, fighting broke out in country X, and the majority Binta government changed the nationality law, prohibiting ethnic minority women from conveying nationality regardless of the mother's citizenship or the father's ethnic group. Although the law on its face appeared prospective, the government of country X applied it to anyone regardless of when they were born. When Martha heard this was happening, she rushed to the authorities to request a copy of her birth certificate, but she was told that because her mother was Bunta, that she was not a citizen and was not entitled to any official documentation from the government. They told her to report immediately to the police with her passport that she had been issued years prior. Martha, who had heard reports of others in her situation being arrested and some even tortured, decided to flee. Using an existing U.S. visitor visa, she traveled to the United States, where she overstayed her visa and her passport expired in the meantime. The civil war in country X continues, and the crackdown on non-Binta has only intensified. So with that information, Martha comes to your office, and we're going to talk to Lindsay first about what information from UNHCR's perspective would we want to gather on this case.
Sure, of course. Thanks, Colleen. So from a starting point, or the key starting point, I think, is the question, is she stateless? Is Martha stateless? So looking at some of the elements of the facts that we actually have, and there are many other facts to explore here, but based on what we have, the information we have in the hypo, it looks as though Martha was actually born a citizen. This is by law, the existing law at the time, that her mother could convey citizenship, her father could convey citizenship. So she was actually a citizen And then she also apparently met all of the registration requirements as well. They provided the birth certificate and all of the proof that they needed. So it seems that Martha she met the requirements and was born a citizen of Country X. But it appears we need to look at additional developments around citizenship. And when she was 20, it says that the nationality law changed and did not allow mothers of that ethnic minority to convey their citizenship, though it was actually a facially neutral law in some ways. Not necessarily neutral. Mm-hmm. Sorry, I should say it's not facially neutral, but it did apply prospectively, not retrospectively on its face. It then seems to, as the hypo notes, that it was actually in practice applied retroactively as well by the authorities. So even though the law itself said it should only apply moving forward, by operation in practice, the authorities seem to have applied it retroactively. So in effect, it seems that by operation she was denationalized in a way and was no longer considered a citizen. You can also look to the statements and actions of government authorities as proof of that. So looking at the way that when she approached government authorities, they refused to give her a birth certificate and actually told her that she was no longer considered a citizen. And if you can look to the practice of others who were similarly situated to Martha, that also may give rise to a finding that she was actually stateless. Additionally, I think so. It appears, based on the basic facts, there are many questions additionally that we should ask and think about other documentation that could be provided to prove her statelessness. But it appears that, very quick facial read of this, that she is not considered a citizen or national of any country under the operation of its laws. I would just flag, too, that an additional fact that could potentially be explored, or an area that could be explored, related to the expired passport, that could potentially also answer some questions about whether or not she actually is considered stateless, would be if she had gone to try and renew her passport with the authorities at the embassy in the United States, and what their reaction was. I mean, many times some of the stateless people that we have encountered in the U.S. Have attempted to go to the country that they felt that they were a citizen of, and were actually specifically told by the consular and embassy authorities that they were actually not considered a citizen of that country. So those sorts of statements can also be very helpful in proving the government's position vis-a-vis that individual as to whether or not she is a citizen or national of that state. One question that's not put out here at all, it doesn't appear to be this, but it doesn't look like Martha has a claim to citizenship in any other country, but it would be important to ask her whether or not she has a claim to citizenship in any other country, because if she does and actually is a citizen, then she would not be considered stateless. One important thing to note is that if an individual is eligible to apply to naturalize as a citizen of a country, but has not yet done so and is is at this moment not a citizen of any other country, then she is in fact stateless. Just the opportunity, the availability of the availability of an option to apply to naturalize does not a citizen create. So it's important to remember that statelessness is a snapshot in time. Are you stateless in this moment, regardless of whether or not you have an option to naturalize otherwise? I think I'll turn it over to Dree.
Sure, and that's a really great summary of kind of the initial analysis of is my client stateless. Once you've determined they are stateless, which I think Lindsay was very convincing in doing so, then we again look, are they a citizen of another country? If they're not, then our next step as attorneys is, well, let's establish their country of last habitual residence. So then we want to look through this fact pattern and for ways to kind of argue that she last habitually resided in country X, if that's the country that she is seeking asylum from, which she is here in this hypo. And so it looks like she lived most of her life in this country, in this hypo. Her parents were both citizens of that country, and I think that, you can make a very strong case for last habitual residence being there. It doesn't seem like she's lived anywhere else here, and so I think it's a pretty straightforward case for showing last habitual residence in country X. Looking to, well, what is the persecution? Did she suffer any persecution yet? I think that is a good question. I think there's nothing in here that stands out to me as rising to the level of persecution. It's all kind of lead up to persecution. She left shortly after the law, and so didn't suffer kind of any of the effects of how being stateless in country X was. However, I think there's a really good argument that you could still make that it is persecution per se, because there's evidence that it was denaturalization based on ethnicity. And so I think there's some good case law that can help you there from some of the slides that we provided today, basically saying that denaturalization based on ethnicity, maybe it's not per se persecution, but it might be. And so you definitely want to make that argument, even if you don't have a ton of harm to point to. And then in the alternative, obviously you would argue that she has a well-founded fear of future persecution because of, this law and how, it's clearly targeting people from her mother's ethnic group. And then the facts there in the last bullet point about how the crackdown on non-Binta has intensified. So you'd want to explore those facts with your client more about, well, what does that mean? What, how are non-Binta being treated? Things like that. Why do you think that would happen to you? And what are your individual risk factors of that actually happening to you as well? And again, seeing if you can maybe find an expert who can help you show a pattern in practice of persecutory acts against non-Binta in this country. As far as nexus goes, I think, here we've got clear ethnic groups, so race, that would fall under race. And then also there's an element of gender as well, because the law itself prohibited only ethnic minority women from conveying nationality. So you'd want to explore any kind of gender discrimination issues as well. Maybe that's a sign that, since it's Martha, I assume that's a woman, that, she might be subject to some kind of gender discrimination on top of, her mixed ethnic background. And so you definitely want to explore those issues as well. I think those are the main things that I would flag and really dig into with my client. It doesn't seem like there's any firm resettlement or one-year deadline issues here, since she came in on a visitor visa shortly after and then overstayed. But maybe she overstayed a really long time before applying, in which case you'd have to explore whether she meets one of the exceptions to the one-year deadline as well.
Okay, great. Thank you, Dre and Lindsay. Now, I think we have a couple questions. If you have questions, again, you can type them in on the right-hand side. All right, the first question that we have is, are Palestinians per se stateless? Their passports are issued by the Palestinian Authority, which is not recognized by the U.S. government as a state. Lindsay, do you want to take that one?
Sure, great. I would just say, statelessness is a case-by-case determination. So it is a specific determination in an individual circumstances. So there may be certain populations that have high degrees of statelessness within the population. However, it is very key, particularly when representing stateless people before U.S. immigration authorities, to be very clear that the individual circumstances in a person's case give rise to statelessness. And so that's going to be a very critical piece, regardless of anyone's origin and any documentation that they have. Additionally, I would just say, from a pure UNHCR perspective, whether or not a country is recognized by one country as a state is one that does not necessarily figure into the analysis from UNHCR's perspective. I mean, again, you are stateless if you are not recognized as a citizen or national of any state in the world, and then looking at other factors, or looking at the factors as detailed in the actual handbook. Though under U.S. law, I would defer to Dree if that's a creative argument that an individual might want to raise related to the impact of the U.S.'s not recognizing a particular state as a state itself. If that might be something you might want to raise as a creative argument in proceedings.
Yeah, I think you could. As far as asylum goes, it really matters what the persecuting government is doing and how they interpret things. But I think it's certainly worth exploring the effects here as well, at least because asylum, as we know, is a discretionary benefit. And so making an argument for statelessness, and then also explaining that, the U.S. doesn't even recognize, their citizenship of a certain country, and this is how it impacts them here if they're not able to have a pathway forward to eventually obtaining citizenship, then that can be a helpful discretionary argument, I think.
Yeah, great. Thank you both. Another question, I think you talked about this a little bit already, but if the persecution is not based on statelessness, is it necessary to argue that an asylum applicant is stateless?
Yeah, I think, again, this is another one of those case-by-case questions. I think you need to think through, are they stateless, obviously, is number one. If they are, how does this help me? How does this help my client? Think through all the different legal elements where that might come in and be helpful to you. And then thinking through practically, how can statelessness be an argument in favor of my client, even if it might not be directly related to their claim. Again, going back to the early identification of statelessness slide, talking about, credibility issues, maybe discretion, prosecutorial discretion, maybe avoiding detention, things like that. So there's other benefits to making an argument of statelessness beyond just, whether your client is eligible for asylum. So I think you really want to think through all of those different aspects of relief and do an analysis of pros and cons for, is it too much trouble to raise this, or is it actually something that's probably going to be really helpful to my client in many different ways?
Yeah. All right, great. So unless there are any last minute questions, again, you can type them in if you have any. I just want to reiterate what Lindsay said, that we're going to be sending out this recording as well as some other resources, including the representation manual after the presentation.
And additionally, I would just say, just one last plug, the manual, I would definitely recommend looking at the manual. There's some very valuable practice pointers all through it. And this is the first edition of the manual. So we hope that there will be many more editions informed by your practice, your experiences in all these different areas of law. So we really look forward to receiving your feedback and also look forward to hearing from you as you represent your stateless clients, if you have questions or any of those or any issues come up, please do feel free to reach out to UNHCR for assistance. And we also highly recommend making use of UNHCR's wealth of resources on statelessness that are available on our website and beyond. So thank you again to Dree, and we look forward to continuing along this area of practice with you all. Thank you very much for all of your work on behalf of stateless people.
All right, and thank you for joining us today.